The meeting will begin in 1 minute. The meeting will begin in 1 minute. Thank you.
Welcome to the Land Use Committee meeting, Tuesday, April 18th, here in Carnegie Town Hall. And our first order of business is approval of minutes. Can I have a motion to approve the minutes from our last meeting?
Move to approve.
Okay, move to approve Councilor Staley, seconded by Councilor Selberg. All in favor say aye.
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 Opposed, same sign. Passes unanimously. Okay, and we have one presentation. Rental housing registration updates by our very own Councilor Michelle Urbanbach. Welcome, Councilor.
Thank you. It's a pleasure to be here this afternoon. I appreciate you taking the time as a committee to review some of this with me. I wanted to tell you just a little bit of the history of this particular ordinance. It came about almost 15 years ago now. Councilor Darren Smith led the charge with this particular ordinance when it was first adopted by the City Council at that time. It has served us well, but it is at a point now where the city needs to look at it in terms of making some improvements and some tweaks, and so we've kind of gone after that. But before we get into that, I just wanted to talk a little bit about the Central District in Sioux Falls. That's the district of the city that I've represented now for 7 years. And it's been, one of the great joys of my life to be on the city council, but it has been the most interesting area of town to be in service to and with. I think that my number one phone call over all 7 years has been regarding my neighbors or my landlord or my tenants. It very often comes down to that idea of rental properties, how they're maintained, and how the people are, how they behave who live there. And so the tweaks in this ordinance came about as the result of long conversations with a lot of neighborhoods. I have attended neighborhood meetings, and I have coffee with different groups, and I've sat on some porches in some interesting parts of town and seen all kinds of activity over the years. And this, what began to formulate was this idea that as the City of Sioux Falls grows, so do those issues that come with rental property and property maintenance. And so we looked at, it actually was City Attorney Dave Fifley and I, 2 or 3 years ago, finally said, is there something that we really could do to start to make a difference for not only the people who rent the property, but the people who own the property and the people who are neighbors to the property. And so we started batting around the idea of something that's collectively called housing court. And housing court is really a mediation service that the city would provide, and it's done in several organizations, several cities our size across the country, and then in some that are larger, including St. Paul. And so we started by talking with someone who lived in Sioux Falls and had previously worked for housing court in St. Paul, Minnesota. And as we kind of walked down that road in conversation and collaboration, came to the idea that that's a really big project. It is something that the City of Sioux Falls will need to do at some point as the city grows, that we will need to set up that mediation system. And you'll hear today, I think, from some landlords who say, help me deal with this issue and that issue and that issue. Be more proactive for me. And that, what they'll define for you is a model for housing court. And so I would encourage future councils, future leaders of this community to think about what that would mean, to study it and to lead us in that direction. So instead of taking on that massive monster in the couple of years, because I started this conversation a little over a year ago, in the 2 years that I had left in my term of service, I didn't think housing court was going to happen, and Mr. Fifley didn't either. And so we brought a group together that included several city staff and included people from fire department, people from health, police department. We have lots of planning and zoning people. We have code enforcement. Matt Tobias was a key player in this project. And we brought in Stacy Teason from the Homeless Advisory Board just to talk about housing issues in general and how might we get to housing court, because that was the beginning of the conversation. And then we came back to the rental registration ordinance and said, what are the things that we can do that would be easy wins and that would make a difference for all three of the sort of audiences that I was thinking about? This will make a difference not only for the tenant who rents maybe a substandard place, it will make a difference for the neighbor who lives next door and is absolutely sick of dealing with whatever it is that's happening in that substandard housing. And it will also make a difference for that landlord who thinks the tenant is mowing the lawn, or thinks the tenant is clearing the snow, or thinks that the house is in perfectly good order, but has really no idea. And so this really does build winning situations for all three of those audiences that I was looking at as we began this conversation. So I'm just going to walk through very briefly the changes that we've made to it. You'll see that it's on the screen, then you also have it, there are copies of it for the public as well. It's largely unchanged from the original document written, as I said, nearly 15 years ago. You'll see that what we've done, if you look at the first change, is in section 150.177, it's subsection A, changing the number of days for the owner or designated agent to notify the city in writing about a change to the information that was provided in the original application. We changed it to 30 days, and you'll see that we did that in a couple other instances so that it's consistent throughout the ordinance. And then if in your paper copy you look at the top of the second page, this for me is the crux of the solution that we're providing for this particular piece. Again, very small step, but what it does is it puts in the hands of not only the city, but of the tenant and of that neighbor who may be concerned about that property, puts in those hands the name of a person a real live person who lives nearby, who they can call, who the city might text, or the city might email, or the city might call and say, there are issues with the property, there's an issue with your tenant, the snow hasn't been removed, you want to go get the snow removed before we start charging you like the city does. It gives that local contact. And the thing that I've learned, again, in these last 7 years as I've dealt with code enforcement issues is that we're really talking about a small percentage of landlords. Most of our landlords are rock solid, wonderful people who are taking good care of their property, providing, different levels of housing, including affordable housing, for those lower income folks. They're doing a great job, but there continues to be that small percentage who creates issues for us that are wasting taxpayer dollars. We spend far too much city staff time chasing these people down and not finding them. And so the requirement will be that if the owner doesn't live in Minnehaha or Lincoln County, if the owner doesn't live in either of those counties, the owner needs to have someone, a real live person, and it doesn't have to be someone who's licensed in any way. It doesn't have to be a real estate agent. It doesn't have to be an attorney. It might be if I decide I'm moving to Phoenix and I'm going to rent out my house here in Sioux Falls, I might have my son-in-law or my cousin or the guy down the street, someone that's a real live person that will take responsibility, that will make sure that the snow is shoveled, that it's mowed, that the windows aren't broken, that if there are excessive police calls there is a real live person that you can contact that can make a difference. We find that many, and I'll have Matt Tobias talk about it as well, many of those landlords who have less than desirable properties don't live anywhere near Sioux Falls and could really give a rip. They don't care. They don't want to be involved. They just want to make money off of the property. And again, very small proportion of those owners. But we want to take that ability to be so callous about our community. We want to take that ability away from them. We want to put it in the hands of, again, a real live person. The next change you'll see just a little bit farther down, about halfway down the page, talking about it's a proposal for an inspection for non-permitted residential rental units. It is one of those pieces that I've had conversations with South Dakota Multi-Housing and with other folks, and it is one of those pieces that's certainly up for debate. But I want you to think about it in terms of being kind of the one thing that we might be able to use to convince people to register. Rental registration in Sioux Falls doesn't cost a dime, and it gets you those perks in terms of that instant contact. It gets you that ability to make a difference with maybe a problem tenant, and it doesn't cost anything. And so we've put in there that idea of, so you didn't register, we're going to inspect the place and charge you $25 for it. Cheaper to register, and that's really the thought behind that. We can have conversation about that. Farther then down at the bottom of this page, this is also another piece that we'll be talking, Paul Bangford, who has helped us write this ordinance, we'll talk about this a little bit as well, but talking about the idea of if there are multiple code violations and there are issues with a particular property, that even if we take that person to court and they're not found criminally guilty, we still have that option to find resolution in perhaps civil litigation or in other ways. And so that piece is in there as well. Then if you flip, if you have the paper copy, it's the top of the third page, just talking about the idea that, again, this is almost a housekeeping thing, that whenever the city determines that any residential rental unit, and we take out whether permitted or not, it's really meaning just saying any residential unit, rental unit has failed to meet requirements. So we're just cleaning up that language. And then just a little bit farther down, that last paragraph, we're just using that idea, the terms owner's designated agent. That's again that real live person that's here in either Minnehaha or Lincoln County close by that takes responsibility for that. And this then is the transfer of the permit if, for instance, again, I've moved to Phoenix and I've rented out my house here in Sioux Falls and I've decided my son-in-law is my designated agent. He and my daughter pick up and move to Indiana. And so I need to find another designated agent. I need to let the city know within 30 days rather than 60 days. That's one of those things that, again, to be consistent across. The one at the beginning was 15 days. We changed it to 30. This one's 60. We're changing it to 30 as well. So just to follow up then, we have just these very basic changes, all really positive. We have had conversations with South Dakota Multi-Housing, and I have city staff here that are going to help me with this. I need to thank Jim David as well. He's been instrumental in keeping us on task over the last year as this group of folks has been meeting off and on over a period of time. And I also have thanks to Matt Tobias for his leadership in code enforcement. One of the things that I need to make very clear is that idea that, yes, I do represent the Central District and the entire city of Sioux Falls, and yes, I do have a lot of contact with code enforcement issues. And our city staff, led by Matt Tobias, who is that manager of code enforcement, are doing just a rock star job when it comes to following up with these things. I was just telling Matt that, over the years it's gotten quicker and quicker, but if I share an address or I send a citizen to Matt, the response time is just almost overnight and very often within a few hours. And they really do go in and make a difference in those neighborhoods where problem properties are. So this is one of those pieces that is just going to give Matt one more little tool in the toolbox. It does make it an easier situation for all of us as we, again, continue to grow as a community and try to maintain that, kind of housing opportunity that we want Sioux Falls to be. So with that, I'm going to open it to questions, and we're going to kind of, as a team, answer them. If it's a legal question, Paul's going to jump on it. If it's more of a code-related or an enforcement-related, Matt's going to jump on that. Jim and I can talk about wording and whatnot, but open it to questions at your prerogative, Mr. Chair.
Okay, thank you very much, Councilor Rippenbach. Questions of the councilor from members of the committee? Councilor Neitzer.
Since it doesn't cost anything, do you have a sense, or does anybody know why people don't register, since it seems to be in their best interest?
That's a great question, Councilor Neitzer. I don't know. It's one of those things that, especially, kind of oversee 2 houses in Sioux Falls because my mother lives in a different neighborhood than I do. And I struggle with that idea too. Why would you not want someone to know, want the city to know that you're, especially if we're going to make it easier? The other piece of it for me is, why would you not want it to be public that you are following that law? I mean, if I'm a young person wanting to rent one of a more affordable apartment, if I'm going to look at that list of people that are registered, that seems like a perk to me, that I can tell that it's been registered with the city and that it makes more sense. I don't have an answer for that, though, really. All I can do is guess. Matt, do you have a better guess?
I'll just add. Matt Tobias, Planning and Building Services, Code Enforcement Manager. With that, that is a good question. We would like to see our numbers be higher because the way, from a code enforcement perspective, the way I kind of look at this rental registration ordinance is kind of an insurance policy for a landlord, because I look at that. If it's during the snow season, if you're a registered rental, we're going to call you. If we have a phone number we're going to call the designated agent. We're going to make that phone call. It's just our communication with code enforcement. If we have an issue at the property, we're not trying to track down, trying to figure out who lives there or whatnot. It's a point of contact for us. But yeah, that. Why people aren't doing it, that's a good question. I will say, since some of the publicity has gone out about in articles in the Argus and whatnot, I've received a lot of phone calls from people who owned rental property and said, I didn't know this was an ordinance. I didn't know I had to do this. So it's really I'll say on my shoulders right now and some other city staff shoulders to get the word out that this is an ordinance and we do want to have people register these properties.
After somebody might get a fine for shoveling or something because they weren't registered and you didn't get a hold of them, when you have the opportunity, do you let them know, if you would register,
Yes.
we'd be able to tell you,
all the
and then you
time.
wouldn't have this fine. And then did they say, oh, okay, I'll register,
Yes.
or is there reticence?
Yep, all the time. We send out, I bet my staff probably sends out on average, I'd probably say, at least 5 to 10 of those a week. Our first question when we get a complaint on a property and we find out there's a rental property, is it registered? If not, here you go. Here's a registration in the mail. So that's one thing that we're doing and we're going to continue to do.
Okay, good.
Yeah. Good.
Councilor Selber.
Thank you. Probably have a question while you're up here. That kind of ties into my question. Do people know about it? How do they know about it? How do we advertise that they have to have a permit?
That's it's another good question. With what we're doing now, I mean, call it a PR campaign. Call it what you want, but we need to get the word out that we do have a rental registration ordinance, and we do want your properties registered. So it's right now the ordinance was written in 2004, I believe, so it's been on the books for quite some time. And it is, like Councilor Vermaak, like she said, I mean, it's time for us to kind of look at this ordinance and make sure it still makes sense. And in this case, just make some tweaks to it to get the word out that, hey, we do have an ordinance on the books. So it's little ideas like that. I mean, if we have to do press releases, press conferences, whatever we need to do, but we need to get the word out that this ordinance is out there, and it's an encouragement. And then there's not a fee associated with it. I mean, that's something that, in the room, and I hate to say this all the time, but there are other cities that are smaller than us that charge a fee for this. And that wasn't our intention going forward. We did not want to all of a sudden start having fees associated with the actual registration ordinance, because we all know that when you attach a fee to something, that gets pushed on to somebody else, and we didn't want to see that pushed on to a tenant or anything like that. So we wanted to make it as easily as possible. We're going to get this thing to where we're going to be able to fill it out online here very, very soon. So we're just trying to get the word out that, hey, it is an ordinance, and it's in, like I always say, is that from a code enforcement perspective, it is an insurance policy, I'll call it that, because it's a contact for us that's big. Yeah. And if I can, and I've said it before up here, I'll say it again, but if I can make a phone call to someone versus send them a letter, we're going to do that. That's always the way we're going to go.
And if I could follow up real quick. So we're talking about timelines and fees or penalties, that type of thing. Mm-hmm. Have we pulled a lot of permits? I mean, has this been a problem? Like, you'll have an issue with somebody who's not following the rules and you pull their, does that happen commonplace?
No, typically, since, we haven't done that. We haven't. Actually, our enforcement of the ordinance on the enforcement perspective actually citing someone for not registering has been very, very minimal.
Well, not even just that, but let's say somebody's registered, they're breaking the rules and whatever, and
Yeah.
you have to go
And
yank with
that's
their-
kind of, that's, you know, honestly, that's a lot where our conversation started when we first sat down with this thing is, can we revoke someone's ability to rent a property? And that conversation kind of starts there and it ends there really quick. You know, we haven't done that. We haven't done that. And, you know, when like we said, we've met on this for, you know, several times throughout the past year. And I think that, you know, when the smoke cleared at the end of the day, we figured we had an ordinance on the books that worked right now. We just needed to update it and make some modifications to it. And that's what I think we did right here today, so.
Thank you.
Councilor Staley.
Well, I've got a concern about the constitutionality of that, the $25 inspection issue. And we have the inspection warrant right here, and put that in everyone's packet. Apparently, to go onto someone's property and do an inspection, you have to have a warrant to do
Yes.
that. So how are you going to tie that into this? And how are you going to know if it's a rental property?
Yeah, definitely. I'm gonna have Paul
Okay.
to answer those questions for sure.
Counselor Paul Bangford with the City Attorney's Office. Yes, if the section that's currently in there authorizes the city to do inspections on non-permitted residential rental units when we become aware of them, if they're not registered and we become aware of them. With that authorization, the advice from our office is always, as the first step, go and tell them, here's the ordinance, we are seeking permission to come in and inspect the property. If a property owner or tenant says, no, you're not coming in, we don't force our way in. We go to the courts, we seek an inspection warrant. The authorization there that allows us to inspect non-permitted residential rental units is what we use under SDCL 3443-1. That is, you know, if the county or municipal official commanding him to conduct an inspection required or authorized by state or local law, that would authorize us under local law to conduct the inspection, but we don't force our way in. We would get an inspection warrant from a judge if a property owner or tenant did not allow us into the property. That would be the advice.
Don't they have to have means? Doesn't there have to be a reason to have a warrant? So for example, so you're suspecting that John Doe over at 3401 West Wayland is renting their property.
Yep.
You don't know that, so you're going to get a warrant and the property's in fine condition, there's nothing bad happening. You're going to go out to a judge and get a warrant to get into their property? Is that what you're saying?
Right.
And what if they're not renting? What if they're not? It's not a rental situation.
Yeah. We seek the inspection warrant. What happens is and it talks about preparing an affidavit within this ordinance. And you prepare an affidavit from, here's the information we have, here's why we believe it's a rental unit, here is the city ordinance that authorizes us to enter this property, and we set forth all of that information, and there's required information in the inspection warrant statute, and we ask a magistrate or circuit judge to issue a warrant. If they don't feel like there's sufficient information, they deny it. If they feel like we have shown sufficient cause to get the warrant, then it's granted and we have permission to enter the property.
And what are you looking for when you enter the property?
Well, in this particular case,
Evidence that they're renting out to somebody?
yes, I mean, that's what we're looking for on this. The issue then is, do you want evidence of renting it out or evidence that it is a safe place for somebody to live? Are there any plumbing issues? Are there any electrical issues? Anything that from a building services standpoint would make this not a safe place for a resident to live?
But how are you going to determine before you go through all this how there has to be a way of saying it is a rental or it's not? I mean, what's to keep you from going just to a regular homeowner and saying, well, we think you're renting? And let's just say I choose to rent a room to my brother. He's coming to town to go to VOTEC school for 6 months. Mm-hmm. So that means that you could get a warrant to come into my house to see if my brother's renting one of my bedrooms?
Right. I mean, we have to compile the information we have from the sources that we have it, and every case is different. And we take that information If we feel like there's cause to go in, then we can present it to a judge to see if a judge agrees. If we don't feel like we have enough information, it stops there. But then the next step is a judge seeing if, yes, based upon what you're telling me, based upon the ordinance, I agree that you have authority to enter this residence.
So really, we're making it illegal to rent in Sioux Falls without a permit.
It's illegal to do
That's
that
really
now.
what we're saying,
Yep,
right?
it is now. There's a lot of people who don't comply with it, but since about 2004, it is illegal to rent without a permit. Up to this point, we haven't been issuing citations for the most part. I guess I can't remember if any have been issued. There certainly haven't been many, if any. We've tried to use it for an educational purpose to encourage people to do it, but it's illegal now to rent out.
Okay, I get it.
Without
So
that
you
permission, yeah.
do the warrant, you get into their property, you find out that they've been renting a room out, and then what happens to them? And they pay you the $25 to come into their house and tell them, to
Yep.
determine that. Then what's the penalty?
And then there's also going to be a $100 citation in most of those cases issued for failure to register your rental property.
But if everything else is in good shape within the premises, then it's still,
Then it would be the $100 plus the $25 for not registering and causing the inspection. Yes.
Do we have any other members of the committee that have questions for anybody that has presented or maybe waiting in the wings to present? Councilor Neitzer?
Would the fee for not registering work or stand on its own without the inspection clause?
You're asking if that was removed, would we still be able to seek the $100? Or
Well,
I guess
I guess I'm asking, if you're looking for maybe a stick to get people to register, so if you just had a fee to people for not registering and not an inspection, could that stand on its own, or would that mechanically not work?
No, and that's in effect now, and we can cite people $100 for not registering their rental property now. Yep.
Oh, okay.
Yes.
Okay. So, yeah, the $25 is in addition for doing this inspection.
Correct.
I don't have a huge feeling on this, but the must reside in either Minnehaha County, South Dakota, or Lincoln County, South Dakota. I guess I'm not even sure who to ask about this, because I'm like most of the stakeholders in the room that I'm looking at, I'm guessing are good, honest landlords that are not the problem. So if Matt has a thought as to why the Minnehaha County and Lincoln County versus, I don't know, a mileage or something, within 60 miles, or I don't have a...
Turner County?
That is it's a local contact for us. And let's say that usually we can, I had to, this past winter, I had to call a guy who owned a property, lived in Hawaii. And I had to say that you need to shovel we received snow, we had a complaint on your property, you have 48 hours to shovel your sidewalk. And he told me from Hawaii, that is absolutely ridiculous. I cannot get that done in 48 hours. I mean, that's a real life situation that happened this year. So it's that local contact to someone maybe has some connections here that can at least get someone out there right away as soon as possible to take care of the problem.
I could almost see somebody who lives in Laverne,
Yeah.
maybe owning a property here, and they could drive over.
And that's very true. And we just thought we'd keep it simple here, saying Lincoln and Minnehaha. This is all up for discussion too. So
Yeah, okay, and then may I ask another one?
Yes.
Is this agent that's designated, which it looks like you could already designate an agent, the only change is where they live.
yeah.
Is there any, if I decide to be an agent, my brother owns a house here, but he lives in Colorado, and I raise my hand and say, yeah, I'll take care of, if something comes up, you can call me. Do I take on any legal liability as far as fines, or is that rests solely with the owner?
And we always, all the fines are associated back to the property owner in that case.
So if I don't get over there and do it, it's not like I'm going to be getting fined.
No,
my brother still gets.
Your brother's just going to be mad at you, probably.
Okay.
Any other questions? Councilor Staley?
Down to the one that's talking about.
Just one second.
Sorry,
I'm
Councilor
sorry, Councilor.
If you don't mind, Mr. Chair, I just wanted to add to that it has to do with the state lines as well. I mean, yeah, I know people that own rental houses that live in Laverne. It's the state line thing. It's just, we're just trying to keep it clean. And as Matt said, try to keep it simple. Maybe it would be the 4-county MSA or something. I mean, if we decide that, but the state line thing is an issue with that particular.
It gets more complicated legally to reach people if they're outside the state?
Yep.
Okay, thank you. That makes sense.
Okay. Pardon the interruption, Councilor.
So that's
Sayles.
fine.
Go ahead and proceed.
Down to, the one that's talking about, like you could override what a court would decide about liability. Paul, maybe you could.
Again, Paul Bangford with the City Attorney's Office. The intent of what is in there is generally citations are issued. We don't take a large percentage of cases to court for criminal prosecution on nuisance cases. We certainly take some, but not a large percentage. So most of these are going to be citations, which is why it's in there that it's irrelevant that the dwelling owner or others were not criminally prosecuted, because we've issued citations, they've had a chance to appeal. The other part of that, or were acquitted criminal charges for the incident serving as the basis of suspension. There are two different standards that are involved in criminal court and in civil court. In criminal, we have to prove it beyond a reasonable doubt. In civil, it's by a preponderance of the evidence. So that gives the authority of the city, even if court has determined that we haven't proven it beyond a reasonable doubt, to make the decision that we would proceed because we believe that there is sufficient evidence by a preponderance of the evidence. Now, the safeguards that are in place, and I understand the concerns with that. The safeguards that are in place is if you revoke somebody's rental permit, there's different decisions the city could make. We could say, you know what, we couldn't prove that case beyond a reasonable doubt, but we still think that we had a sufficient preponderance of the evidence case, and we're going forward with the fact that we have 4 violations. Or we could say, you know, because of that decision, maybe we're going to wait for the 5th violation to do it, so we don't have to count that. But this statute, as it is right now in 150.178, says that that revocation of the rental permit does not go into effect until you have exhausted all of your appeal rights. So maybe somebody is just going to appeal it to the administrative hearing officer, and then if they don't get a favorable ruling, they may decide, I want to appeal this to circuit court. It's at any point in the process, somebody can stop and say, I'm done appealing, I'll just accept the decision of the last one who made the decision. But there is a chance to review that decision either through the administrative hearing officer or circuit court, or ultimately the Supreme Court if you disagree with other decisions that are made. So it gives the city the option of pursuing it, but it is still internal review, court review, and potentially Supreme Court review that would follow if a person chose to take it that far in terms of whoever the landlord was.
Well, and I just happen to know of an individual who got caught into the code enforcement cog of harassment and did end up taking it to court and paid out of their own personal pocket to defend themselves and were found not guilty, and it still hasn't been resolved within the city. So I'm hesitant to go anywhere that is going to give the city more authority over what a court would decide, just for the record, okay?
Sure.
Okay, Councilor Neitzer.
I don't know if there is here or not, but something I was thinking about after Councilor Staley talked about an example. Is there any delineation, or should there be, for let's say, I don't know if it makes sense to say this, an owner-occupied rental versus one that isn't? I mean, it seems like it might be a little different to me if I live at my house and I happen to be renting the basement to my brother because I'm there and I can take care of my property, versus living in Arizona and renting my property out and being absentee. That would in maybe the former case, maybe they don't need to register, or that there should be some other rules. Has any thought about that? Because I mean, the whole point is being able to reach somebody. Yep. And if I live there, well, you can get to the owner pretty easily. So I guess it's just a thought.
We're just kind of back and forth, but my question to Matt was, how would that be different from a twin home? I own the twin home and I live in half of it. The other half is still a rental, you know, so how would that be different? I mean, not.
Sure,
I mean,
a duplex
it's not something we
situation.
thought of, you
Sure, I
know?
buy a duplex, I rent one side and I keep the other. Oh, okay. I mean, whether I'm 10 feet away or 100 miles away.
Right, exactly. And, you know, to a question that was asked earlier, we've looked at those owner-occupied, you know, because you get, in South Dakota, you get a tax break, a property tax break for being owner-occupied. So we've looked at those lists as well. That's one of those things that very clearly delineates, you know, whether it's a rental or not. Most of those are.
And we do have access to that stuff, and that stuff we do look at to determine if it's a rental or not.
So,
Occupied.
you know, do you mind if I ask another question?
Go ahead.
Something else, there are all kinds of records of who owns properties, things like that. Is it terribly, well, I suppose it's easy enough to find a name and maybe an address, but to figure out who actually owns a property, I suppose it's one thing to figure out who owns it, and it's yet another thing to get a hold of them.
Yeah, true.
Because you don't necessarily have a good phone number for SunTrust Bank or whoever.
It's once again, it's that element of it's a contact. I mean, it's a good contact. It's a good person we can talk to who can address the issue we have with the property, whether it be, you know, sidewalk snows, trash in the yard, or whatever. I'm just still kind of just going, I'm undecided on all of this. I'm just kind of going in circles and just trying to think, you know, this obviously is more of a stick approach to get people to register. I'm just mystified when it seems to be in their best interest why they don't register. It'd be an interesting question to get an answer to. So. Sure.
Okay, seeing no other questions, I do have a few of my own, or maybe comments.
Mr. Chair, I apologize again.
Counselor.
If once all the questions are asked, there are members of the public here that do want to speak, so if we make sure that we have time for that as well.
Sure.
That would be concerned. Yeah. Thank you.
Okay. Yep. And I do understand that this is really for the protection of the property owners surrounding these properties as well, too. Is it not true that the likelihood of anybody even coming to the attention of others, is slim and none if everything on the property is within code, especially on the exterior side? Of course, you can't view the interior. I know Councilor Selberg had touched on it earlier. Have you developed strategies to get the information out regarding registration of rental properties, and are there not still rental agencies available that could help and assist with that distribution of information too, as property owners contact them?
That's something we've definitely talked about. We've even talked about getting in touch with some title companies. You know, get in touch with the title companies when the title transfer takes place, when someone buys a property and it's going to be a rental. You know, here's a step in the process here. Let's get your properties registered with the city. We've talked about a lot of that, but I think a lot of our time and effort has been putting into this. But definitely the next phase will be, you know, how do we get that message out? What are our strategies to let people know that this ordinance is on the books? So that's in my opinion, that's probably our next big step with this.
Okay, thank you.
Yep.
And then just before I invite members of the public forward, Councilor Erpenbach, I do believe that you've indicated you would like this committee to help provide some direction as to the next step that you take.
Yes, Mr. Chair, if I would like to have that conversation that, you know, certainly there are, and the members of the public that are here will have some wording tweaks as well. We've already had some of those conversations with them, and we decided to just leave it as is so that it can be more collaborative. Let's talk about why the wording is that way or why it should be changed. But yeah, absolutely, I would like this committee to consider, you know, sending it to the full council, you know, either through an informational session or directly to first reading, but it has to be, it's at the discretion of this committee.
Okay, at this point, I would invite members of the public to come forward to address this issue. If you would just please identify yourself and your place of residence.
My name is Brian Majors. I live at 811 North Fairfax, and I'm here representing South Dakota Multi-Housing. I'm chair of the board right now. Just a real quick beginning, it seems to me if the incentive or reason we're here is to try and get people registered, there's got to be other ways to do that than to start talking about changing the ordinance. And I would simply start by saying, I've been told now for 5 years of going out to the legislature to testify that every county knows exactly what properties are non-owner occupied. And if the county has that list, I would suggest we get a hold of that list and start contacting all non-owner occupied properties that are out there. Now, does the county have it or not might remain to be seen, but we've been told for 5 years the county has that list. We do really have some concerns about using the term agent and continuing using that term agent and expanding upon the responsibility of that. From our perspective, the term agent, when you're talking about real estate, carries some real definite responsibilities. Mm-hmm. If you want just a secondary contact, then just ask for a secondary contact. Get rid of the word agent. Just say we want a secondary contact so we can reach those people. We're really not sure you accomplish much by saying they need to be in Minnehaha County or Lincoln County. I'm not sure what difference it's going to make. Quite frankly, from my perspective, and I think if you talk to some of the other landlords out here, if you have a landlord that's absent and living in Hawaii who doesn't care, it is very, very likely that their secondary contact that you have isn't going to care either. He has no reason to care. He has no legal responsibility to care. So you can call him up and tell him that the sidewalk needs to be shoveled, but what are you going to do with him if he decides not to shovel the sidewalk? You've informed somebody else, but it still doesn't mean that that sidewalk is going to be shoveled. So without legal responsibility, nothing's going to change there. We do have concern about just saying because a rental unit, a rental apartment, rental property is not registered, that you have reason to enter. If there is no cause, there's nothing to indicate that the property has any violations, everything looks good on the outside, you haven't heard from anybody that there's a problem inside, it seems to me the city is saying just because it is not a registered unit, we're going to enter it. If all you want to do is get that person to register, then why not just simply contact the person who owns the property and tell them they're in violation of city ordinance and you need to get registered or we're going to fine you for not being registered. Entering the property doesn't seem to have any relevance to being the fact that it is not a registered property with the city. Last, we really have a concern about the whole concept of saying it's irrelevant that the dwelling owner or others were not criminally prosecuted or were acquitted of criminal charges. We think it's very relevant that the property owner was acquitted of criminal charges. Mm-hmm. Enough that, we know we'll have to have further discussions on that with our attorney who represents our organization to make sure that this is wording we can live with. But at this point, we're really saying we think it's very relative. If you've already been found innocent, why are we going back again and going to tie up the courts with where we know the landowner is going to go right back and say, well, they've revoked my license, and the court have already said I wasn't guilty. So we're right back in court again. So we think that whole paragraph there, that section has to be reviewed. I'd be happy to answer any questions, but I know there are other landlords who are here who probably wish to speak.
Any questions of Brian, first of all, while Brian's forward? Brian, I do have a question regarding the secondary contact, and I might be somewhat in agreement with you with the Lincoln and Minnehaha County residents. You could have Turner County residents that are closer than somebody who lives in northern Minnehaha or southern Lincoln. I think that's probably an easy tweak that could be done, just designating X number of miles within the state, if crossing state lines is problematic. But if you have a secondary contact, doesn't that give you an avenue that otherwise does not exist? I'm not certain that I fully agree with you that it makes absolutely no difference. I think that's an assumption.
Excuse me. I think you can have a secondary contact, and as I said, if we got rid of the word agent in there, just saying a secondary contact as part of the registration is not problematic. I think you're right that a distance comes into play. If I live up in Flandreau, is there a reason I couldn't be your secondary contact? I'm not sure what the advantages are to the city one way or the other where that secondary contact lives in what county. I'm not sure it makes any difference. I would just reiterate that from my perspective, if that property owner living in Hawaii doesn't care, I'm not sure the secondary contact is going to care. You know, a property owner cares, he's going to take care of the problem. His representative isn't going to care any more than the actual owner cares.
Thank you, Brian. Do we have other members of the public that would like to come forward?
I'm Gerald Gherkin, Brandon, South Dakota. I'm one of those people that live out of town. But you talk about registration. All my units are registered, and I got a letter on trees, and guess what? They use the county, because I can tell when they use the county, because the county's got different title than what the city has with my name. And the letter I give Greg had Gherkin Trust on it, and you won't find that at the city. So the city's not using registration. They're going to the county and looking up the owner anyway. And as far as being in Hawaii, I could be in Hawaii and leave here on a Saturday and snow on a Tuesday and not get back till the weekend, and I'd be in violation of the ordinance. And if I had to hire somebody, you would have to have a property manager to manage property, because that's state law. You just don't say, hey, Joe, will you handle my property? Because he's violating state law then. So that's it.
Okay. Thank you, Jerry. Any other members of the public that would like to speak?
Good afternoon. My name is Ron Savi. I'm a property owner. I'd like to address the question about why people don't register. In my opinion, there's two reasons. Number one, might be, I hate to use the word, a slum landlord that's afraid to register the property. But I did not register my property for about 4 years, and I've been in the business 10 going on 11 years. Because of complete ignorance. Now, I own property in Minneapolis. I ended up getting a license. I left Minneapolis. 10 years later, I buy property in Sioux Falls. And it never occurred to me that I need to register the property. It wasn't until I joined the South Dakota Multiple Housing Association that I found out. Now, I'm not sure how many people we represent that are landlords, but our organization certainly is not 100% of the registered landlords in the city. I do believe there is a way to get the message out. I was one of those people that did contact the Director of Equalization, and I didn't get a list, but I got the number of non-owner occupied properties in Minnehaha County when we were working out on our legislation. I'm not going to say it's easy, but it's not difficult, because as a property owner of your residence, you get a 30% tax break. We do not get that as property owners on rental properties, and that is split out. It might take a little paperwork to get that done, but there is a way to get that. But by the way, I'm not against this. I really see the benefit of registering your property. It is something that I would encourage every property owner. The problem is probably the person that bought a house, a starter home, and then all of a sudden maintain that, went on to another house, and then rented that out. That's probably where you're getting some problem. I don't know where this boundary, and I want to address the distance. What happens if I move to Rock Rapid? I mean, I'm 9 miles away from Sioux Falls. I don't understand the boundary of everybody's getting caught up with the state line. In my opinion, it should be just a, I don't know, 50, 75-mile radius from Sioux Falls, in my opinion. And I am also very concerned about the language of agent. There's some legalese in here, and it kind of bothers me because everybody's saying, don't worry about it. But what's a natural person? That's a legal determination designed by agent, or is it designated agent? Once again, is agent a legal term? And do we end up violating state laws or conflicting with state laws in regards to the term agent? That's my concern about that. So I just wanted to express that. Thank you.
Thank you very much, Ron. Welcome.
Good evening. I'm Denise Hanslick, an Executive Director for South Dakota Multi-Housing Association, and I reside in Del Rapids, so not in the city limits. But I do want to inform you of, as a user of this list. Of course, our association represents about 18,600 units in the city of Sioux Falls. Now, that is not everybody that is registered. I believe as far as the registration list, there's about 35,000 units. And I use this list to prospect because I'm all the time looking for possible new members in our association. And I can't tell you, when I send out letters with the information that is on the registration list, how many I get back. I bet I get a quarter back of what I send out. So the information that's on the rental registration is not accurate currently. So we really need to do, not only get the word out that rental properties need to be registered, but also so that we get that information updated. And we do inform our members that it is an ordinance, city ordinance, that they have to be registered, but we're willing to do anything more that we can do to help to get the word out.
Thank you very much, Denise.
You bet.
Any other members of the public like to address the committee? Any additional committee questions? Well, we do have a member of the public here. Welcome.
I just can't help myself, I guess. Christine Erickson. As you know, I have rental property, and I wanted to address the issue of not being registered. As I wasn't registered for quite some time until actually Mr. Tobiasen came to me and we talked about it, and I said, oh my goodness, you know, totally didn't have an idea about that. So I think that certainly there is some ignorance on the part of just not realizing it's something that you need to do. It is free, so it is to my benefit to do it, and so I appreciate that. The other thing that I wanted to just talk about, as we look at the residential rental unit definition, one of the things, my business is a little bit different. We don't do traditional rentals. We do short-term furnished rentals. So we're traditional, just we were long-term, we're just a regular old rental. But I would like to see something addressed eventually with the platforms that are used, from Furnish Finder, shorttermrentals.com, Airbnb, VRBO. There's these platforms that a lot of people use that there is a need in the community, you know, and this is what we do for our business. With that, there also comes a sales tax liability, and my husband and I do have our sales tax license, and we remit sales tax on a bi-monthly basis every 2 months. And but I'm almost certain most do not, and I've talked to the Department of Revenue, a friend of mine, as I worked there as well. We discussed this very issue just a few months back and talked about, in Sioux Falls, the rental rate in the city limits of Sioux Falls is 10%. That's a lot of revenue that we could potentially be losing. And so I think that that is something that could eventually maybe be a part of this conversation, or after this is done, to address that kind of platform, as well as being also another type of residential rental units that are offered within the city of Sioux Falls. When we talk about snow removal and things of that nature. You know, yards, not that big of a deal. We can get around to our yards within 5-ish days. But for us, if we're out of town or we're on vacation or we go back home to where my parents live for Christmas time, I have to, as a landlord, have to make accommodations. So I'll call a snow removal place and say, hey, you're on standby for the next 5 days. If you can get us in, let us know. And so that's what we do for it. We don't designate anyone when we leave as far as any issues with our property, but we certainly make sure that all of our properties are taken care of when we're gone for the safety of our tenants, as well as just not abiding by those ordinances. And so it's a pretty easy fix with that. But I just wanted to mention those couple of different platforms and, you know, offer any expertise if anybody has questions in regards to that down the road if we get to that point. So thank you.
Thank you. I do have a question for anybody that's able to answer it. How does the county determine non-occupied or occupied by owner or non-occupied by owner? Do they rely on the owner to identify that? I mean, because there's a lot of individuals that have lake homes and occupy both their home in town as well as out at the lake. Because my question is, are they, the disadvantage of registering then identifies the fact that it's not owner occupied, and so then my taxes are going to be higher. I mean, that's a disadvantage of registration.
And somebody can correct me if I don't have the exact, we have a second residence in Watertown, South Dakota. It's just a small little place that we've had for 12 years. And so for us, we don't reside there. It's a second residence. And so it would be non-owner occupied because our main residence is here in Sioux Falls. And so we can get mail there. It's registered in our personal name. But because it's not somewhere we live for a substantial amount of time, we do pay the higher taxes on that because we occupy it, but it's a second home. I don't know, Marshall, you might be able to, excuse me, Councilor Selberg, you might be able to educate more on that being a realtor with the second home type thing, but I know that's how we do it, is it's not our actual living quarters for us, it's just a second residence.
So is it not possible to have two owner-occupied homes? You got to designate one. Okay, Mr. Jim David was indicating one. Yes, Jerry.
Yes, we just bought in the last 2 years about 5 homes in Sioux Falls. Every time you buy one, the county sends you a letter and asks you if it's owner occupied or if you're going to live in it.
Okay.
Because my address is Brandon. So they send you this letter, and there's a lot of fines and stuff that go with the letter if you say the wrong thing. So we always fill out the letter and send it back to the county, and then they add the taxes on it.
Very good, thank you. Got the answer to my question. Councilor Neitzer.
So I think, I'm just going to say, I think the intent here is laudable, and because I think there's a good reason for the owner to get registered, but also for the neighbors. I mean, I understand, you know, like if Matt can't get a hold of the absentee landlord who isn't taking care of the property, and you got neighbors who have to put up with all this garbage. I think there's a public good in being able to track these people down. So I think adding some teeth it does make some sense. I will say, however, and so maybe there should be a fee for not, and I'm not sure how it would work, and I know there's already a $100 fine, but maybe a fee that we're talking about for not registering. I have a lot of consternation about the city may inspect any non-permitted residential unit and then looking at an inspection warrant, because the way that I read state law, simply by virtue of the fact that the city says that they can inspect a non-permitted residential rental unit, the fact that you are a rental unit and you're not registered, therefore, would give the city cause to get a warrant to go into your property. And that seems to be far too low of a bar when it comes to due process. I mean, it just seems like you're just turning these people into criminals. So I don't know about that part. The other part is the irrelevant, and I had a conversation with Paul Bankford about this, about the dwelling owners. I think we need to think about that maybe a little bit. So I think this has merit. I think it just needs maybe a few tweaks to get there.
Jim David, Operations Manager for the Council. I think I might be able to clarify. If you go to 150.177 and subsection 1, I think it was maybe Councilor Neitzert or Councilor Staley who had brought up the phrase, or maybe it was somebody giving public input, the natural person. So really this applies to if you are a corporation, you're not a natural person. So if you are a business, maybe you're a business that doesn't reside within Sioux Falls, maybe you're a bank that resides in New York City, you need to have a designated representative or an agent from Minnehaha, Lincoln County. And the reason why the counties were chosen is if you have a distance, it's a distance from what? 60 miles from what? 60 miles from downtown Sioux Falls, 60 miles from the city limits. It causes some confusion. So maybe in talking with Councilor Erpenbach, there's an opportunity to expand the number of counties, but the intent was to give certainty to where these representatives could reside. And so that's just part of your conversation.
Okay, thank you. Councilor Neitzert.
So by this wording, it's saying that only if the actual owner is not an actual person, there has to be a secondary person identified. Only in that case. But if
Councilor Neitzert, Paul Bankford on behalf of the city. That is what it says. That's not what it's intended to say. It's supposed to be if either a person or business entity isn't here. You're right. The way it is currently worded would just cover if you were not a natural person, but that was not the intent, and the intent would be to modify that language to reflect that if you're not living local.
yeah, because as it stands today, if I'm a real person and live in Hawaii, I don't have to designate anybody by the strict wording here. Okay.
Any other questions? Because I think I'm going to go back to Councilor Erpenbach. Would you like to say anything in closing?
Absolutely. Thank you, Mr. Chair. I do appreciate the conversation, and as you've noticed, there are pieces and parts they're moving all over the place with this. And so I think it's important to understand that this is how government works. That government is not just one or two people sitting up here and saying, this is the way it's going to be. This started with a group of citizens that live across this community. This became an idea for a couple of people, and they brought some more people together. And then they put some words on paper, and they goofed up some of the words, and we realized we repeated some of them and we did them wrong, but we did some of them really right. And so I want us to understand that this is how it works, and this kind of collaborative conversation is going to move this forward. And this is the kind of thing that I appreciate the committee spending time with. I hope that either that the committee decides either that we'll retweak and bring it back to the committee. You can look at it again. I mean, we've taken copious notes on the conversation today. Maybe we bring it back to the committee and then to informational. I don't want this to be something that we just do overnight. This is something we need to continue to have conversation about. So yeah, I absolutely support it. I think that it's the right thing to do. It is to the benefit of so many people in our community, but it's something that we need to continue to work on a little bit. So
okay, thank you, Councilor. And my feeling is that maybe it would be best if you retweak it and then bring it back to this committee so we can do this all over again before we go to an informational or before we go to a first reading. Just gives us a little more opportunity to take public input, and I'm throwing that out to everybody now. So Councilor Selberg.
Right. Yeah. Thank you, Councilor Erpenbach. I think it's a good proposal. I think this program has a lot of merit. It does a lot of good. I think there's some tweaking that needs to be done, but what program that comes out ordinance doesn't. So I would probably second exactly what you just said. Tweak it a bit, come back, and go from there.
Good.
Councilor Staley?
And I just wanted to say that I appreciated you allowing the public to give input
Sure.
to the Land Use Committee.
But we hate to have them sit throughout the entire meeting without any action on their own. So thank you very much to everybody that did come in. I think it was valuable to have that input.
Thank you.
So I think we have is there a consensus that they can tweak what has been discussed, bring it back to land use again in the future? All right, good. I think we have direction then. Gee, we didn't get to talk with Mr. Cooper, but he talks quite a bit, so we'll move on. All right, so now we're moved on to open discussion. Any items of open discussion? I do have one, but you have the priority. As I had announced at the 4 o'clock informational, the annexation task force next meeting is scheduled for Wednesday, April 26th, right here in Carnegie Town Hall from 5:30 to 7, and that is a change from the original schedule. So originally it was scheduled the day before at the library at 2, so erase that from your memory bank and replace it with Wednesday, the 26th, right here at Carnegie Town Hall, and we look forward to our second meeting. So, seeing no other discussion, this meeting is adjourned.